CPR 8.1 is concerned with the types of claim in which the Part 8 procedure may be followed. 1. The Part 8 procedure is the procedure set out in this part. 2. A claimant may use the Part 8 procedure where A. He seeks the court's decision on a question which is unlikely to involve a substantial dispute of fact, or B. Paragraph 6 applies. 2a. In the county court, a claim under the Part 8 procedure may be made at any county court hearing centre, unless an enactment, rule or practice direction provides otherwise. Practice Direction 8a includes further direction in respect of claims which are not made at the appropriate county court hearing centre in the first instance. 3. The court may at any stage order the claim to continue, as if the claimant had not used the Part 8 procedure, and if it does so, the court may give any directions it considers appropriate. For paragraph 2, does not apply if a practice direction provides that the Part 8 procedure may not be used in relation to the type of claim in question. 5. Where the claimant uses the Part 8 procedure, he may not obtain default judgment under Part 12. CPR 8.3 concerns the acknowledgement of service. 1. The defendant must A. File an acknowledgement of service in the relevant practice form, not more than 14 days after service of the claim form, and B. Serve the acknowledgement of service on the claimant and any other party. 2. The acknowledgement of service must state A. Whether the defendant contests the claim, and B. If the defendant seeks a different remedy from that set out in the claim form, what that remedy is. 3. The following rules of Part 10, Acknowledgement of Service apply. A. Rule 10.32. Exceptions to the period for filing an acknowledgement of service, and B. Rule 10.5. Contents of acknowledgement of service. That is A. Be on the relevant form. B. Be signed by the defendant or their legal representative or litigation friend. And C. Include the defendant's address for service, etc. CPR 8.5 concerns the filing and serving of written evidence. 1. The claimant must file any written evidence on which he intends to rely when he files his claim form. 2. The claimant's evidence must be served on the defendant with the claim form. 3. A defendant who wishes to rely on written evidence must file it when he files his acknowledgement of service. 4. If he does so, he must also at the same time serve a copy of his evidence on the other parties. 5. The claimant may, within 14 days of service of the defendant's evidence on him, file further written evidence in reply. 6. If he does so, he must also within the same time limit serve a copy of his evidence on the other parties. 7. The claimant may rely on the matters set out in his claim form as evidence under this rule, if the claim form is verified by a statement of truth.